Let's see. Yeah, $5,938.79. That is correct, Your Honor.
Okay, and that included a bonus, correct?
Yes, Your Honor.
And then you subtracted what, 250.22 and
215.22.
215.22, and then also the $12.22.
As this hearing begins, the courtroom sparks immediately. Dad suddenly questions paternity despite signing legal acknowledgement years ago. The judge isn't amused, and the tension skyrockets. With support modification on the table, every word matters. This case is about to twist fast. Subscribe for more dramatic courtroom breakdowns.
A request by the attorney to transfer this matter to district court. Before this matter is transferred, however, it does appear that the parties are also requesting DNA testing, which the state would object to, Your Honor, as there is prior order naming the non-custodial parent as the father, and there's a signed AOP on file for the parties as well. However, again, there is a request for the DNA testing by the attorney.
This is a modification y'all pled, correct?
Yes, Your Honor.
Yes, Your Honor.
Okay, well, paternity is not an issue if it's a modification.
Well, Your Honor, if I may.
Yes, ma'am.
And we understand that, this may be denied, but it has come to my client's attention that he may not actually be the father of this child after all. Even though there is an acknowledgement of paternity that he signed, initially no DNA testing was ever done. I'm looking over this order that was from, I believe, 2019. It says it is found that Gerardie McHenry, the father of the child, has a duty of support. It does not specifically adjudicate him as the father of the child. And so we would ask that because of these concerns that a DNA test be done just to confirm moving forward. However, if it is denied, we can possibly bring a termination at that point, if that's what my client wants. But instead of having to go that whole other route, why not just get a DNA test done now?
Well, the problem is that he signed acknowledged paternity. That adjudicated his paternity, not the court order. The acknowledged paternity is a legal finding in Texas that when you sign a document like that you're admitting you're the father, you're saying you don't want DNA testing, and that you understand that by signing it, you're legally establishing yourself as a biological father. Court orders thereafter wouldn't establish paternity because paternity was already established in that acknowledgement. It's been over, this is a 2019 case. I'm not sure how old the child is, but at least since the case was filed,
he's 10.
5 years. So it's very unlikely that any judge would grant DNA testing.
I understand, Your Honor.
So, I don't see why there would be, and in addition to that, of course, and probably even more important than that, or at least equal to that, is there's already a court order established, or an order already that I cannot overturn, that's probably not able to be overturned by bill of review either, because it's over 4 years. So I don't see any possible way. And if he wants to do DNA testing on his own, he's always able to, but he's going to be legally responsible to pay for this child until the child turns 18 under current law. I don't see any reason there'd be an exception here.
I understand, Your Honor.
Okay. So, I'm denying the request for DNA testing. Does that change anything as far as what we need to do? Or here just on a modification of support?
No, Your Honor.
Okay. So you're wanting it to be referred to district court for what reason?
Yes, Your Honor. So given that he's confirmed that he's adjudicated as the father, he's looking to possibly change possession and access and possibly conservatorship regarding the child. And so that would make this a complex case.
Has anything been filed yet?
Oh.
No, go ahead.
Ms. Williams, please stop talking while I'm talking. I'm talking to the attorney. Give me just a moment. All right. So has anything been filed at this point?
No, Your Honor. No counter petition has been filed as we had first been asking for the DNA test.
Okay. If there's nothing filed, I can refer to district court. Do y'all want to do a hearing today on the modification issues? It's just child support and medical support, and that always can be changed if custody changes later down the road, of course. But are you ready to proceed with the case?
If the case is going forward, we are ready to proceed, Your Honor. I've got my client's 2024 W-2.
Okay. Mr. Tatum, are you ready, or do you want them to go back to negotiation?
I think we can probably just move forward with the Your Honor.
Okay, go ahead and take the lead then.
Yes, Your Honor. At this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
Ashley Williams.
And the name of the child that we're here in reference to?
Jalen McHenry.
And the name of the child's father?
Rodney McHenry.
And as it relates to that child, how does that child currently receive insurance?
His father has private insurance.
All right. And are you
That he's
requesting?
carried.
Thank you, ma'am. And are you requesting that he continue to cover the child through that insurance?
Yes.
Is that through his employer?
Through his employer.
All right. Thank you, ma'am. And is it your understanding that the father has one additional child outside of this case?
Yes.
All right. And in the prior order, what was the child support was not said? Is that correct?
That's correct, because we were in a relationship.
However, you are requesting child support going forward. Is that correct?
Correct. I'm also requesting arrears.
And as it relates to your request for arrears, do you understand that the state is only requesting child support going forward, as there was a prior orders providing that the child support was set at $0, and that has not been changed at this time?
Okay.
And as it relates to the issue of child support, the state has used the reported income of the father at a net income of $4,809.60 for the calculation of support, and requesting that child support be set at $842. Are you in agreement to that amount?
Yes.
And do you know where the father is currently employed?
Exeter Finance.
And how is it that you know of this, ma'am?
We used to work together, and his employment hasn't changed. He notified me before that he had just got a promotion at the company.
And do you know what he does at that job?
I don't know his exact positions. I don't know.
All right. Do you have any additional information that you would like to offer to the court at this time?
I do want him to have his address updated to his correct address, because he's been using his parents as far as, not being able to disclose that information. So I would like to know where my child resides when he is in his custody.
All right. And do you understand that there is nothing before the court to, as it relates to visitation at this time?
Correct.
I'm sorry, could you repeat your answer, ma'am?
Oh, yes.
All right. Nothing further from this party, Your Honor. We'll pass this witness.
All right, Mr. Donakis, do you want to have any questions for Ms. Williams?
Just a couple, Your Honor. Ms. Williams, you do understand that the last order, no child support was ordered, correct?
Correct.
Okay, so we're just asking for child support moving forward, correct?
Correct.
Okay. Now, if it comes to light that my client's wages are actually a little bit less than the OAG has reported, are you okay with the calculation based on those wages?
Yes.
Okay, no further questions, Your Honor.
All right. Mr. Tatum, go ahead.
Yes, Your Honor. At this time, Your Honor, the state would like to call Mr. McHenry. Mr. McHenry, can I get you to state your name for the record?
Yes, Rodney McHenry.
And Mr. McHenry, are you currently employed?
Yes, sir.
And what is it that you do for a living, sir?
I'm over a risk and risk management.
And you have one additional child outside of this case, is that correct?
Yes, sir.
Does that child live with you?
We have a 50-50 agreement.
And are you paying child support for that child?
Correct.
And you are covering the child for the insurance through your employer, is that correct?
Yes, that is correct.
And do you agree to continue to cover the child through your employer for the insurance?
That is correct.
All right. The state has used your previously reported income from your employer with a net income of $4,809.60 for the calculation of support today, and requesting that child support be set at $842 per month. Are you in agreement to that amount?
No, I'm not.
And could you explain to the court why you don't agree to pay the child support based off of your prior reported income?
I think my income can change. Again, I think that income was calculated off of a bonus that's not a guarantee. So I think it would be a fair assessment using what my biweekly pay is versus what a yearly summary is. Again, that can include a bonus that can or cannot happen depending on the company's performance, which I have no control over.
So just to confirm, you received a bonus last year, is that correct?
That is correct.
And did you receive a bonus the prior year?
That is correct.
So could it be assumed that you will most likely receive a bonus going forward this current year?
Yes, I think the amounts change is, I think, my main concern.
Thank you. Just one moment, sir.
Okay.
And as it relates to the child support, the state made the request that this child support begin as of May 1st, 2025, if the court was to order support. Are you in agreement to that date?
Can I defer to my attorney on that?
All right. Nothing further from this party, owner.
All right, Mr. Donakis, go ahead.
Yes, Mr. McHenry, you pay medical and dental support for the child, correct?
That is correct.
How much per month for the child do you pay in medical support?
I would need to calculate that. Again, my insurance covers my other child as well. We have a family plan for dental and medical.
Would it be correct to assume that it's $250.22?
Correct.
And dental $12.27?
Correct.
And that is just what was previously reported to me by you, correct?
Correct.
Okay. And you work at Executor Finance, correct?
Exeter Finance, yes, ma'am.
Exeter, I'm sorry.
No
and your
problem.
2024 W-2 gross annual wages, would it be correct in saying that was $71,265.47?
Correct. Again, that includes a bonus, but correct.
Okay. And so based on what you're providing for medical and dental care and that W-2, my calculations come out to child support is $813.63 a month. Is that something you're willing to pay at this point?
No.
No. Okay. Do you agree with the calculation?
Yes.
Okay. All right. I'm going to, may I ask Mr. Tatum, do you have the 2024 W-2?
So again, Your Honor, not for sure who she's
She's asking you, counsel, if you have the return.
the wages that we use were reported from the employer from last year, Your Honor. And I believe that was at about a gross income of $6,166 per month, net income of $4,809.60.
Okay. Just confirming that. Thank you, Your Honor. Thank you, Mr. Tatum. So no further questions for my client at this time.
Okay. Okay, I have a question about numbers. Okay. So the number you had for monthly gross was Aronakis was $5,938.75. Is that correct?
Let me pull up that 1 minute, Your Honor. Let's see. Yeah, $5,938.79. That is correct, Your Honor.
Okay. And that included a bonus, correct?
Yes, Your Honor.
And then you subtracted what, 250.22 and
$215.22.
215.22, and then also the $12.22.
$12.27, Your Honor.
Okay, sorry. And so then that brought you to a bring home or net income of how much?
$4,649.29.
Okay. And then it was 17.5% of that. Is how we got
Yes,
to the
Your Honor.
813. Okay.
Yes, Your Honor.
Things explode when dad reveals alleged threats, surprise visits, and safety fears, while mom simply wants the correct address. The contradiction is Wildy wants custody, but hides his residence. The judge's scrutiny tightens, and the tension peaks. This unexpected twist raises serious questions about credibility and parental responsibility.
No further questions, Your Honor.
Okay, thank you. Sorry.
I don't know if I said that. I apologize.
Okay. Let's see. Is there any reason, Mr. Anakis, why Mr. McHenry is not sharing his address with Ms. Williams?
Not that I'm aware of.
Do you want to ask him some questions on that before I make him disclose that?
Yes, I can do that, Your Honor.
Go ahead.
Mr. McHenry, is there any reason why you're not sharing your present address with Miss Williams?
Yes, there is.
Can you please explain that to the court?
Yes, she's made a history of verbal threats towards myself and my current spouse. She has a history of showing up unannounced at places. This has been documented. I have Ring doorbell footage of this as well. I think it's more along the safety of my current partner and myself that our current physical address not be shared again with the current threats that have been presented towards myself and my spouse via phone call and text message.
Okay, Mr. McHenry, have you ever called the police and made a police report?
No, she was gone at the time when the original threat happened, so we were not in a place to make a phone call.
Okay, are you in fear for your safety and your current partner's safety if your address is disclosed?
That is correct.
Okay, and have you ever filed any protective order against Miss Williams?
No, we were able to reconcile that to where nothing was filed at that time.
Okay, no further questions, Your Honor.
Okay. What are the dates of these alleged threats, Mr. McHenry?
Excuse me?
What are the dates approximately of these alleged threats?
I would need to go through our phone, but there were multiple in July and August, and then in October and November.
Well, this is July, so you're saying it happened in the future, or you're saying it happened another year?
I'm sorry, it happened in July 2024. I apologize.
Okay. And the last one was what? September of 2024?
The last one was in February of
Okay.
2025.
Okay. All right. As far as the issues we have here, obviously, I don't know why you're bringing up DNA testing, Mr. McHenry. Kind of insulted, kind of angry about that. That doesn't make any sense. You're responsible for this child. This child calls you dad. I don't know why you're bringing up that. Makes no sense to me, but I don't know. There's just doesn't make a lot of sense there. So,
May I speak on that,
and
Your
then
Honor?
at the other side of it, you want to have custody. That's kind of the opposite. At one point, you're saying, I'm not the dad. I don't want any responsibility. I don't want to see this kid ever again. And the other side of it, you're saying, I want the kid to live with me. Those two things do not go together. You have a responsibility to raise this child. You have a financial responsibility. You're going to have that even if you don't like it. Your bonuses and commissions and tips, in addition to your regular wages, are income. You get to spend them. They are your income. I understand that it can vary from year to year. We try to average it out over a yearly period, so that way it kind of balances out over the 12 months instead of just picking, let's say, someone getting a bonus in December. It wouldn't be fair for me to set child support based on their December income. So if we average it out over the year, I think that makes a lot more sense. I understand you may not have control over it, but you do have some control over it, because the better job everybody individually does, the better the company does, and hopefully then they give you all bonuses. I mean, I know it's not necessarily your control as far as how much it is, but it's your income. So I have to include that in there. So I'm ordering Mr. McHenry to carry health and dental insurance, any updates in insurance cards or anything like that. If Ms. Williams doesn't have an insurance card now, make sure she gets one. If they change companies or something like that, or get new cards, make sure she gets new ones. Child support is $814 per month, based on your wages. I don't know why you're opposed to that. That's what your income is. That's what it should be. I'm not granting your non-disclosure request. You have to notify Ms. Williams what your address is. She has to notify you what her address is. We have a problem, of course, that we haven't resolved today, which is how we're doing visitation. And that's something that we can't get to because we're completely opposite on two different issues that makes no sense from the beginning of this hearing today. What we really should have done today is we probably should have agreed on some kind of visitation, a trial amendment to adding that to the orders, but we don't. We haven't.
We
gotten
do
there
have a
because-
visitation.
I don't think you do. Is there a visitation schedule, Mr. Anaki?
We have a visitation order.
Yes, Your Honor.
So they did an order with no support and then they did standard visits?
Yes, Your Honor.
Oh,
So the
okay.
order just said that there be no child support at that time, but they did order conservatorship and visitation.
Oh, okay. Well, that's unusual. Usually they don't list either one. Okay. Well, then good. All right. So then that solves that problem. I thought we could have another issue there with trying to figure out how to do visitation since we don't have any orders. But if we have orders, cool. All right. So I'm not granting your non-disclosure request, and then all other orders that are not changed by our order today will still remain in full force and effect. So the visitation order, if it's there, is what we need to follow. There shouldn't be any reason for Ms. Williams to appear at your residence at unannounced times, as long as y'all are following what you're supposed to be doing in the court orders. So as long as you bring the child back at the end of your visitation, there shouldn't be any problem with Ms. Williams appearing at your residence, because you're going to be dropping off and picking off at her residence at the beginning and end of your visitation. Court calls bill to Mr. McHenry. The Attorney General's office will draft the order. Mr. Tatum, do you have the counsel's email address?
Yes, Your Honor.
Okay. All right. He will email you a copy of the proposed order for your approval, and then once that's done, then I can sign off on it and then submit. The AG can send out copies. All right. Y'all are excused and are done with court today. You can press leave on the Zoom to exit out. Thank you.
The judge ends everything. Firmly child support set, insurance required, address disclosure ordered, and visitation unchanged. Dad's arguments collapsed under contradiction, and the ruling reinforces stability for the child. Clear expectations, no excuses. For more shocking courtroom stories, legal insights, and dramatic justice moments, like, comment, and subscribe for more breakdowns.